Hi, I would like to just apologize beforehand for all the multiple jump cuts that will be inevitably happening within this video, as I'm still recovering from a sickness and I've been coughing on and off quite frequently. And I would rather do that off camera than on camera. But anyways, let's get into the case. So a bit of background information about this case. It has 3 parties involved. Washington University is one of them, Dr. Catalona is another, and the research participants that he represented and took the samples from are also in this case. Dr. Catalona and the research participants are the defendants, and Washington University is the plaintiff. Biological samples were taken from patients during a prostate surgical procedure done by Dr. Catalona. These samples were then sent to Washington University's GU biorepository by Dr. Catalona, who was an employee of the university at the time and was also an investigator in the study. He has now left Washington University and has obtained a new job at Northwestern University. He would like to continue working on his research there, which was done with the patient samples. He wrote to his prior patients hoping that they will side with him and help him gain ownership of the samples. The University of Washington obviously extremely objected to this, as they believed that they had the sole ownership of the samples, and thus the issue was brought to court. The defendants brought a couple issues up during the case. One was the informed consent, and one was what was the intent of the, gift, as we call it right now, but I'll go into that a little further, and also who it was intended to be given to. Informed consents are part of any studies that have human participation at all. These forms must be signed and agreed upon before the study even takes place. However, all of these forms have a withdrawal clause, which allows the participant to withdraw from the study without any punishment or repercussion. It does not, however, govern the samples that were taken from the patient while they still agreed with the participation. This is why there was a bit of an issue with this, as the defendants wanted to bring up that it wasn't actually intended to be a gift, but a bailment instead. A gift, you're not expecting to get anything back after giving the sample. A bailment is more like a loan, where you're expecting to get it back or something else in return. This is because once it's left the patient's body, it is regarded as biohazardous material, and therefore cannot be returned to the patient and must be discarded as biohazardous waste instead, if it's no longer needed. The defendants also brought up that when the patients gave the donation initially, they intended it for Dr. Catalona and not the university. However, at the time, Dr. Catalona was an employee of the university and was working on behalf of the university to collect the samples. The court approaches this in a couple different ways. They decided that intent is the most important factor in determining ownership. So the university showed intent through the repository's maintenance, administration, control, where only authorized university employees were allowed to have access, or individuals that were authorized by the university from outside sources. It also retained all responsibilities from legal to regulation, both at the state and the federal level, for handling biohazard materials and dealing with them appropriately. The court also ruled that the right to withdraw from study does not extend to your samples as well. It prevents additional samples from being taken from you, but it doesn't govern how prior samples would be treated, and it doesn't grant you ownership of them as well. Dr. Catalona also displayed by his intent and his actions as an employee of the university that he believed that the university had a bit more ownership of the materials than the participants. When he acted as an employee, he routinely destroyed older samples to make room for new ones without consulting the donors that previously supplied these samples, indicating that he was indifferent about the interest and the ownership of the donors. The court found that the samples are solely owned by the Washington University. They also had a couple other issues that came into play that were not part of the legal and regulatory schemes, but more of their worries about the future. They did not want to set a precedent that patients could own their donations and could dictate where they would go. Currently, these repositories are governed by federal and state law and not by personal interests. If it was governed by private interests, it could and probably would lead to biological samples being sold to the highest bidder, because then the person would be determining where they would go. It could also introduce a prejudice and a dangerous precedent for the medical research field, along with the medical donation field, for example, organs and blood, because then it would establish that if in the future a donor could actually indicate who they would want the organ to go to, ethnicity, sex, or any particular type of research. However, that particular type of research might not be as important for the general public as what they wanted to go towards. So thank you for listening to me and bearing with these jump cuts. If you have any questions, please let me know. I'm happy to answer them. Thank you.